So, good afternoon. My name is Kelly Peters. I am providing you today's half an hour, hopefully fun and informative GDPR session on understanding your GDPR compliance. Quick question for everybody. How many of you are familiar with data protection or GDPR? If you could just type yes. Excellent. That's fine if you don't have a lot of experience, it's not a problem. It's all good. So what I would suggest that you do today is if there are questions that come up, do use the chat box, type them in, and what I'll try and do is as I go along, I'll try and answer your questions, and half an hour should go pretty quickly. So, like I said, my name's Kelly Peters, and I am a self-proclaimed data rock star of Databasix. But enough about me. So, data protection is not new in this country. It's been around since the early 1980s. The current iteration, the 2018 law, came about because the previous iteration was 20 years old. Some of you, I'm not going to try and assume how old anyone is on this webinar, but if I take me, for example, back in the late 90s, these fabulous devices, your mobile phone, you couldn't make video calls on, you couldn't do internet banking, Google didn't exist. And today, the concept of doing a webinar with video streaming was just not something that was possible to do. So the legislation had to change, and with that came a whole gamut of new accountability tools. So what data protection ultimately is a balancing act. We as businesses want to collect lots of information about our customers, about our staff, about our prospects. If we were a charity, we'd want to know more about the people that are donating money to us. If we are offering services that are to service users, we want to know what benefits them, for example. However, we must always weigh up the rights and the freedoms of individuals. So, me as an individual, I don't want companies to misuse my data. So, if I'm going to give you information, I want to believe and be reassured by you that you are not going to misuse that data. And we, working within companies, have to conduct that balancing act. We need to always be thinking, do I need this information? If I do need it, how am I going to be using it? How does it help me with my decision making, whether it be to process payments, whether it be to onboard a new client, whether it be to conduct a disciplinary or to offer somebody a job. There, we just need to constantly be balancing is the act of, do we have enough information? So that's, if you take nothing away from today, take away that point that we must constantly be managing this balance, because I'm sure you think that there are companies out there, or I don't know, I certainly think there are companies out there that ask far too much information and do a little bit too much with it that I'm not quite sure about. So I don't want any of you to feel in that position. So, what is new about the law that came in 2018? Well, there are the core six principles of the legislation, which is fair, lawful, and transparent. We must have a purpose for all the data we process. We must only process what is absolutely necessary with the minimal amount of information. We must keep it safe and secure. We must make sure that we only store it for as long as is necessary, and it must be accurate. Now, underpinning those six principles is this concept of accountability. And what I mean by that, and what the law means by that, is how do you evidence that you are processing information fairly, lawfully, and transparently? How can you demonstrate that you're only keeping data for as long as is necessary? How do you demonstrate that your data is safe and secure? So, when we're talking about accountability, we're talking about evidence. And what this is policies, processes, training materials, for example. So, if the Information Commissioner, who is responsible for data protection in the UK, knocks on your door, you can say, here's our policies, here's our procedures, and here's how we train our staff on how to follow those. And it will be The number of policies you have and the number of processes you have and how secure you keep data entirely depends on the type of information that you are collecting. So, quick question: when I say personal data, are you quite comfortable with what I mean by personal data, or would it just help if I explained what personal data is before I talk about accountability tools? Excellent. So, when I talk about personal data, I'm talking about anything that identifies me and you. So, today, an identification would be, because I'm recording this, will be my face, will be my video imagery, and will be my voice. It will also be things such as my name. It will be information you might collect on individuals in terms of their email address, even if it's a business email address. If it's a first name and a last name and it identifies an individual, it is personal data. Any opinions that you capture on individuals, whether it be in your CRM system, your email address, Teams, or Slack, for example, if it relates to an individual, it's personal data. So, face, image, names, it will be home addresses, for example, passport information, it will be driver's license, it will be things like that that identify us, which we all process. We process a whole array of personal data. We will also potentially collect special data, special category of data, which is the more sensitive information. So when I talk about special category, I'm talking about ethnicity, race. I'm talking about if you capture information about trade union membership, health related data, for example, biometrics. So if you collect fingerprints or iris scanning information, that is the more sensitive information. So that's just what we mean by personal data. So anything that identifies me and you. If it doesn't identify me, so it's an info at email address, it's not personal data. Your job description or your job title could identify you. And my job title is Data Rockstar. So if you were to search Oxfordshire Data Rockstar on LinkedIn, you're likely to come up with me. So indirectly, using location and my job title, you're able to identify me. So that's also a way of processing personal data. So the law relates to personal data and how we process that data. So what I'm going to focus on now is the accountability tools. Oh, which you can't see on this slide, which is a little bit disappointing. Hopefully, it came on the handout. So I do apologise for that. So what that slide should show is that there are about 15, 16 different accountability tools. And I'm going to talk to you about today retention schedules. I'm going to talk to you about data breach logs. I'm going to talk to you about audit, a training needs analysis, because and contracts, because I think these are some of the key things that will help us talk through. I believe the handout should have a copy of that slide. It should make it look a little better. If not, I'll send it to you. So remember when I talk about accountability, what I'm asking you to do is to be able to demonstrate um, why you do what you say you do. So one of the legal requirements of the law is something that's called storage limitation. So what the law says is that you should only keep data, personal data, for as long as is necessary. So what that means is that you cannot keep data up forever. Now, I know a number of people that really feel uncomfortable with the concept of having to delete information, whether it be paper or electronic. The law says you simply can't keep it forever. So, what we have to do is we have to come up with a happy medium. So, what all of you should be thinking about in your organizations is what is the different data that we have? So, customer data, employee information, recruitment data, finance data, information relating to suppliers, for example, if you have investors or shareholders, for example. So we need to be thinking across all of those different types of people. What is the data, the personal data that we process, and how long can we store that data? And Why we ask that information is that if we can create what is referred to as a retention schedule, we can then demonstrate to anybody that asks, this is how long we need to keep this information and why we need to keep it for that long. It is a legal requirement that we have a retention schedule. Now, some things are quite easy than others. So, from an employment law perspective, there are requirements that we have where we need to be able to do due diligence. So, we need to be able to prove people have the right to work in the UK. So, we have a requirement to do that check. Um, we also have financial and taxation laws, which say that we need to be able to keep records of PAYE. We need to make sure that we can demonstrate the invoices that we've paid so that when the taxman, or if the taxman wants to audit us, we've got that data for a certain period of time. Now, you might say, well, Kelly, what does a retention schedule look like? And what you'll see here is that you can create retention schedules. I've based it on function because I think that works best for most of the companies that I work with. So here I've got a HR function. You might have an IT function. You might have finance, for example. You might have customer services. You might have suppliers, however, or business development, for example, sales and marketing. So, by function, what you need to be thinking about is the type of data that you're collecting. So, here you can see we have human resources. We've got a record type, which is an application form. Remember, an application form or a CV has a lot of personal data. It has names, addresses, qualifications, education, um, employment history, for example. You'll have then a retention period. So it's always good to think about what's the minimum period that you need to keep data for and what is a maximum period of time. So the best practice by the Chartered Institute of Professional Development, the CIPD, states that you should be retaining CVs and applications for unsuccessful candidates for a minimum of 6 months, just in case they challenge you to an unfair recruitment process. And you might want to keep it for no more than a year because the Limitations Act says that that's the maximum period by which an action can be taken against you. What the retention schedule also sets out is what your disposal action will be. So once you've reached the end of your retention period and you don't have consent to hold on to the unsuccessful candidate's data, you should be disposing of that. So in this instance, I've given some notes to say HR will determine if it was an unsuccessful application, and they will then, if they don't have consent, they will delete the data either from their HR system or from the directory that that data is stored in. You can also see we've got the employment right check. It's a different retention period. It's 2 years. It's based on the immigration order of 2007. So again, you can see here, different types of data will have different types of retention periods. Now, if you're interested, I can give you some examples of retention periods that the CIPD recommends. So if that's something you would like, I will send that out to you. So think about in your organization by function, the different types of records and data that you're collecting. Think about the different retention periods. And most importantly, what do you do when you no longer need it? So that's what we're looking at here when we're looking at retention periods. Now, you may never have experienced a data breach. They will happen and they're probably happening more often than you suspect. It is very easy. Quick question. How many of you have received an email from somebody that then a couple of minutes later said, oops, sorry, that was not meant for you. I sent it to the wrong Kelly. Yeah. Typically, because the auto, when someone's typing an email in Outlook, for example, you'll start typing a name and it gives you a list of names that it sounds or looks like, and it's so easy to select one that you end up selecting sometimes the wrong name. Or the other common one is your name's put in the CC box rather than the blind copy, and then you suddenly had your email address disclosed when it shouldn't have. It's a little bit frustrating, but breaches do happen, and a breach is that your personal data has been shared, it's been accessed, it's been deleted inappropriately. for example. So, what we as organisations need to do is we need to train staff on what a data breach is. We need to have a data breach policy, or it be covered in our data protection policy to say this is what should happen if a breach is identified. But one of the accountability tools is a log file. And here I've given you the top common column headings that I'd want to see in a breach log. So I'd want to know the date, the time that the breach was reported to me. I'd like to know when it was first discovered, because if it happened on a Friday and I'm told on a Monday the breach happened on Friday, but it was actually um, I was told on Monday of the breach and it was discovered on Friday. So I know the time difference. What is the type of data? Is it just email addresses or and names, or could it also be credit card information? Could it be entire payroll files, for example? How many people are involved? So is it just one person, or is it tens of thousands? And to me, it doesn't matter if it's one person or tens of thousands. If it's one person and we've inadvertently disclosed their credit card details and we've potentially put them at financial risk, they're just as important to address as tens of thousands of records. We need to understand the severity of the breach. So, is it going to cause harm, emotional or financial distress? What are we going to do to initially contain it? Emails that go to the wrong person, which only have a body of an email but don't have an attachment on it. An easy containment is to go phone that person and say, look, I've sent you an email by mistake, or you follow up with an email to say, look, you shouldn't have received this. Can you please delete it? And can you confirm you've deleted it? More significant containment would be if you have a virus, IT may come round and shut down computers. They may disconnect you from the internet, for example. And we also need to assess whether or not we need to notify the information commissioner. So a breach log really allows you to be able to capture this information and, most importantly, learn from these breaches, which I'm a big fan of. What we also need to be doing, so, we've got retention schedules now, we've got breach it logs. The ICO do not stipulate how often training should take place. However, it does suggest that it should be mandatory and it should be regularly. So I interpret regularly being on an annual basis, and it doesn't have to be lengthy, but I want to refresh people's minds about what is data protection and what, and more importantly, are our policies on that. But not everybody needs the same type of training. So we really need to be thinking about why is data protection important and who needs to receive that training. So there are cybersecurity risks like phishing scams that we might want to prioritize one year over the other. We might want to really emphasize safeguarding confidential information, depending on what we process. Um, we may also want to make sure that we can demonstrate that we are genuinely trying to reduce the risks of a data breach or a cyber attack. So, what I always recommend, a good accountability tool, is to do a needs analysis. And what you want to do is you want to be able to know across your organization the different roles that exist and the different functions, and then looking in those and say, okay, everybody should receive a basic data protection awareness training, just so that we know everyone is aware of what the policy is, and what we expect them to follow in terms of handling data. Now, what I then might say is HR deal with quite a lot of personal data. I want them to have more specific training. Sales and marketing are very proactive. They are using lots of funky new technology. I want to give them specific sales and marketing training. If I have someone that's responsible for data protection, I would like to be able to offer them much more detailed training. So the needs analysis allows you to do by individual and by role the different types of training that you might want to offer. So basic awareness, more advanced training, like I said, in terms of handling breaches, what happens if someone asks for a copy of their data, um, how do you manage being the lead for data protection. So that is what I'd want to do in a training needs analysis. And as you can see, this is the different types of roles I would look to consider giving more specialised training. It is a good task, as far as I'm concerned. Now, fair, lawful, and transparent is the very first principle of the law, and the transparency element is the privacy notices. So, how do you demonstrate you're being transparent? So, how do people know who you are, what data you process, why you process that information? So, this is what a privacy notice is for. So, you should have one on your website that says, this is what we process. If you use our contact form, this is why we use your data and how we'll follow it up. Employees should have a very specific employee privacy notice, what we process on you as an employee, why we have that information, how long we'll keep it for. You might want one for recruitment because you'll have a lot less information on recruitment than you will on employees. You might want to have one specific for events if you conduct events. So I have clients that will have 4 or 5 different privacy notices. But at the bare minimum, I would recommend that you have one on your website that has who you are, what you process, why you process, and who to contact should they have any questions about data protection, and one for staff, because staff absolutely should know what you process and why you process that information. You will have invariably in today's world, we no longer just store data in filing cabinets or on servers that are hosted in our offices. We will have data that we share with other organizations. We will be using cloud-based providers. So a data sharing agreement essentially is an agreement between you and another organization. So if you're in a joint venture, for example, where you regularly share data with another data controller, so this is someone who decides what's collected and why it's collected, you want a data sharing agreement. And a data sharing agreement is a routine agreement that says this is what we'll share, when we'll share it, and how we'll share that information. Typically, data sharing agreements take place with a lot of public sector organizations and between charities and public sector bodies. But what you should have, if you are a majority of you are from commercial private sector organizations, if you're using any cloud-based system, like I'm using ClickMeeting, for example, or you're using any external third party provider where you are giving them your data, so whether it be external payroll, external HR, an accountancy, if you've got someone hosting your website, for example, if you have a CRM system, if you use anything like Brief HR, so anywhere where that data has been outsourced, you want to have a processing agreement. Now, this is a legally binding contract between you and that organization. And what it most importantly does is it asks that organization to demonstrate to you how they process your data. What would they do if there was a data breach? How do they keep that data safe and secure? And if there was to be a breach with that organization, they have to notify you so you can make the assessment as to whether or not you're going to do anything with that in terms of notifying the commissioner. You might decide you no longer want to work with that organisation because you don't think they're fit for purpose. But do have a data processing agreement. If you're not sure where to find these, if you have cloud-based systems, ask customer support for a copy of that. Log into your account with the third-party data processor. If it's an organisation, ask for a copy of the data processing agreement, or you may issue one yourself. And what essentially it will say is what they process. So is it names, email address, finance data, payroll data, HR, recruitment, and how long you expect them to retain the data whilst the service has been outsourced to them. And again, this is set down in the law. So you should have across your supply chain contracts in place with these types of organisations, and it is an expectation of the law and of the information commissioner. And if you're not sure what one looks like, I can send you a hyperlink from the ICO website. And finally, a real good task, a real good um, check to see how compliant you may be is to conduct an annual audit. And what I simply mean is these are your data protection policies. So this is what you say, what actually happens in real life. So if you say to people they should not get up from their desk and leave their screen unprotected, and you do a random spot check and you find out that people simply don't shut down their computers when they go to get a coffee or go to lunch, your policy isn't really working with your best practice. You might say, we should update our privacy policies every year. Look at your website. When was the last time the privacy policy was updated? Okay, again, not following the process. Um, if you say that you only keep old CVs for 12 months and you to do a search on your email system to say CVs, how many come up that are older than 12 months? So there are simple ways that you can spot check whether or not policy and real life are working. And that's what you should really do when it comes to an annual audit. And finally, when was the last time you trained staff? You know, if you were to do a survey to say who's responsible for data protection in the organization, would staff know and would they get it right? So I like a good, it's not surprisingly, as a bit of a data protection geek, I like a good audit. It doesn't have to happen every year, it could happen every other year, but it's always good to know what your gaps are. So they are just some of the tools that you can use on a day-to-day, well, not on a day-to-day basis, as part of your year-on compliance program when it comes to data protection. It was a whistle-stop tour. You will get a recording of today's session because it's a lot to take in. But I'm happy to take any questions that you might have on anything that I have covered. So I'm going to hand the floor over to you, to the chat box, and let me know. Do you have questions on anything that I've covered or something you thought I would and I haven't? I can see some typing, which is always good. Yes, absolutely. I will be sharing a copy of this recording back to the HR by Tara team. I will then be sharing it back with you, so you can have a copy of the slides and a copy of the recording. Um, any other questions? I've also given you some very simple GDPR commandments and individual rights that I think might be useful to you to share with other staff. Yes, I can send you a copy of an example privacy notice. That's not a problem. I'll make a note and send that to you after today's session. I can see some typing going on, so I'll... So it's a good question. So if from a processing customer data perspective, I would say that everybody should have either an introduction to data protection because they need to understand why they're asking that information from that customer, or refresher training, just so they understand what they're processing and why they're processing that data. I don't think they need any more specialized training than that. Um, if you were processing patient data, for example, I'd want you to have more sophisticated training to understand what confidentiality means and how to protect that data securely. Does that make sense? I can see a few more questions. Absolutely. I can send you. I've got a kind of a handout on retention periods. It's not, it doesn't cover everything because it you will have industry specific retention periods that you might need to consider. But certainly, I can send you following today's session. I can send you example retention periods for client data, newsletter subscriber data. Ah, so in terms of in terms of the six core principles, I'll send you a handout on that so you'll know what they are. In terms of changes because of Brexit, so GDPR and data protection still exist in this country, even though we've left the European Union. So we have UK Data Protection Act of 2018 and GDPR. And at this moment in time, there's been quite a shift in government over the last couple of months, as you're all aware. But there is a new data protection bill that is going through Parliament, and we are expecting its final iteration to be available next year. Um, in that, there may be changes in terms of changes to definitions of personal data. There may well also be changes to whether or not we need things like cookie consent statements. The government are not keen on those and want to banish those. But if they do happen, I will then be running another webinar to keep everybody up to date on that. So yes, I do expect changes to happen, and I do expect them to happen next year. And if it's something you'd like to attend a refresher, I will let Tara and Stacey know when that's available so you can join that. Now, I'm conscious I have slightly run over time, so if there are any more questions, feel free to type them in the chat box. We have a catalogue that you're able to download if you're interested in. You can also, that says all of our training and all of our offerings. If you want to go to our website, we have a resources page as well that allows you to download free resources. We've also got a blog that's for GDPR for beginners, which sets out the entire principles of the law and what we mean by that, including an A to Z of data protection. Feel free to follow us on any of the social media platforms that we've got going on, as you can see on the screen. If there are any other questions, feel free to use them in the chat box. I can stay online for a little bit longer. However, I don't want to keep you for longer than the prescribed half an hour. I hope this has been a very useful, if not whistle-stop tour of data protection. And like I said, if you've got questions, let me know. If not, feel free to email me afterwards, and I can respond to it. But I will send you a draft privacy policy, in an indication of the retention periods, and I'll also send you what the 6 core principles are. So if there's nothing else, I'll let you all head off for today, and thank you very much for your time.